Thank you very much, Mr Chairman. I'd like to reiterate some of the comments my colleagues have made on this, because my colleague David Cunliffe looked at the supplementary order paper, which was tabled on Wednesday, or Tuesday, but this week, the 70-page one, and went through some of the commencement dates there. Yesterday, if we have a look at the actual bill itself, we have commenced. What Clause 2 says, this Act comes into force on the day after the date on which it receives royal assent, except as provided in this section. Now, Mr Chair, we've got Section 104, 1st of January 2005, Section 88, 90, 92, 93, 1st of April 2005, and those dates have been, so it's obviously retrospective legislation. Section 92B, 1st of April 2006, Sections 90B, 91, October 2007, Sections 11, November 2007. There's a whole lot of sections that go from 23, some in the 30s and the 40s and the 60s, 70s, 80s and 108, 1st of April 2008. Section 64, October 2008. Section 82, October 2009. There's a whole lot of sections that come in April 2010. More sections, July 2010. A couple of more sections, August 2010. Another section, just one section, 5th of August 2010. Then 31st of October 2010, 1st of April 2011. Then, as Mr Cunliffe mentioned, you go to the supplementary order paper and it runs it out to April 2013. I think it probably would have been easier to list those sections that in fact did receive royal consent than actually list the ones that didn't. There are so many dates here, it is confusing. It is confusing. And to tell the truth, Mr Chair, I don't think it needs a date. I don't think the Minister cares. I don't think he cares. The only reason he has a date is I think he has to by law, doesn't he? He has to, but he doesn't care. Because if he did care, then he wouldn't throw down a 70-page supplementary order paper a day before it's debated in the House, a week before we break for Christmas, and then say to Labor members, OK, this is you go for it now. In fact, the Minister said to us, we gave a briefing, my officials gave the Labor members a briefing. He gave us a briefing on Tuesday, or it was Wednesday, at our request for about 40 minutes on one small part of the bill. And we had no idea this was coming in. So the commencement date is a bit of a mystery, and as my colleague Honourable David Cunliffe mentioned, there is no transparency and no accountability. And the problem that I have with this, Mr Chair, is as a member of the Finance and Expenditure Select Committee, as well as a member of Parliament, I'm accountable for this bill. Because this bill will go through and it will say that it went through the Finance and Expenditure Select Committee. Well, the truth is less than half the bill, as it will end up, went through the Finance and Expenditure Select Committee. The majority of the bill didn't go through the Finance and Expenditure Select Committee, and it should have. And it should have. And we've made that point, and I think it's a very valid point. And I've had a couple of emails saying, yeah, good on you guys, because this isn't right. And one of them is from a tax lawyer. And I'll tell you what, he'll be rubbing his hands all the way to the bank. But there was another thing, that this will come before the Finance and Expenditure Select Committee. I know it will, but do you know how it will come? It'll come as a remedial matters bill that we have to go through and make a whole lot of changes that we would have made in Select Committee anyway. So let's go to the title of this bill. This could be called the Taxation Being Done Over Bill. And of course you spell done, D-U-N-N-E, over bill. Now the reason I say that is the initial bill was introduced on the 5th of August. The 5th of August, and it received its first reading, I think, on the 19th of August. Now Minister Dunn told us that the reason why he needed an SOP is because there wasn't enough time. There wasn't enough time to put a proper bill in. But Mr Dunn also told us that these changes were signalled. These changes were signalled in January when the tax working group came back and outlined what it wanted to do. These changes were signalled when the IRD, the Minister's Ministry, put out a consultation document. These changes were signalled in the budget. There's 3 sets of signalled changes there, Mr Chair, and they all happened about 6 months ago. The budget came out, I think, on the 14th of May or the 21st of May. Since then, there's been June, July, August, September, October, November, Mr Chair. Thank you, Mr Chair. And we're in December. Well, the Minister said we had to take this bill to consultation. Well, he had 6 months. In fact, he could have done that in 3 months. He's asked Labour MPs to do it in 2 days. Why couldn't he have asked high-paid consultants to do it in 2 months? Now, 2 months, 10 weeks. How about that? 10 weeks of consultation. That's enough time. We ask members who are submitting to the Finance and Expenditure Select Committee to have their submissions in 5 weeks. That's what we ask them. But we suggest now 10 weeks. That's enough time. These highly paid tax consultants, 10 weeks. That would have brought the bill back, what? June, July, perhaps. He could have got something drafted up with all their recommendations put in there and given to the Finance and Expenditure Select Committee in August, when the initial bill was actually introduced.
Democracy is paying the price for
it very much is. And I wonder what the Minister's been doing. Is he a lazy Minister? I have heard from my colleagues who know Peter Dunn a lot better than I do because they've worked with him, that he was a stickler for process. This is not a bill from a Minister that is a stickler for process. Okay, let's talk about this. Consultants 3 months. Then that would give the FEC another 3 months to look at that bill. But of course, as I mentioned, we asked for submissions and we could have given them 4 weeks. And then so they would have brought their submissions in, changed it, and 2 months later, this bill could have been introduced about 6 weeks ago to the, had been finished and reported back to the House about 6 weeks ago, Mr Chair. That is why I say the taxation being done over bill. It could be the taxation by SOP bill, because this is taxation legislation by supplementary order paper. And what that means is this, no taxation without representation. What this actually means, Mr Chair, is the Minister has put a huge, substantial part of tax legislation on the table with 2 days for us to look at it. I personally don't think that that is right, and it certainly doesn't show any measure of accountability nor any measure of transparency. It could be called the Taxation Law Society Appreciation Bill, because a lot of this legislation, Mr Chair, is going to be decided in the courts. And I'll tell you why it will be decided in the courts, because this has not gone through due process, which would have really tightened up the legislation. Now, I can say as a member of the Finance and Expenditure Select Committee, the drafters do a fantastic job. They draft some very good bills, and I'm sure this bill, in its supplementary order paper, will have been well drafted. But what the FEC allows, or what the Select Committee process allows to happen, is we just go through almost line by line, like the Minister Trevor Mallard said that used to happen in the House and committee stage. Well, the Select Committee does that these days, clause by clause, and we have the drafters sit down and say, yeah, okay, we might have made a mistake there. They cross-reference everything. And even in the third report back, they say, okay, we have some changes to make. That could have happened this time. There is no excuse in my mind for this legislation to be passed under urgency through SOP. It is not good process. But there are going to be lawyers and tax consultants that make a lot of money out of this. Now, Mr Chair, we have a small problem, and the problem being that the banks, and I'm not bringing the banks into this, but the banks had to pay back about $2 billion in tax. Now, why they had to do that is because they interpreted tax legislation one way, and the Commissioner interpreted tax legislation another way. There was confusion, and this is what happens when there is confusion. Taxpayers don't get it right, and the liability can be huge. And knowing the lawyers that the banks used, I can imagine their bill was huge. So there are a number of bills, Mr Chair, there are a number of names, Mr Chair, that this bill could have been called that are so much more appropriate than the Taxation, GST and Remedial Matters Bill. I mean, let's be honest, Remedial Matters suggests that sort of a tweaking, it's a tidy-up. It's a correction, it's not substantial legislation that in fact wipes away 130,000 legal entities. This removes the loss attributing qualifying company, and it was done under a supplementary order paper. There's no transparency there, Mr Chair. There's no transparency there, and that's why I have real concerns about this, and it is why the name of this bill does not accurately reflect the substantive quality of this bill, or quantity of this bill. GST and Remedial Matters. GST you sort of get the